Yeah, today I want to talk about two very recent cases. They just got published yesterday from the Federal Court of Justice with regard to possible trademark infringement in case of platform internal search engines. So the defendant was Amazon. And yeah, the two decisions are Ortlieb, which is in Germany quite famous producer of bags, and GoFit. They produce some fitness mats from Austria. And they both filed for trademark infringement through all instances. And they have been decided together now, or not together, but in the same light from the Federal Court of Justice. And they did quite a neat case differentiation when it is a trademark infringement and when not. Yeah, before there's been a long ongoing cases with regard to trademark infringement in case of search engine use. For example, if you use AdWords, meta tags, keyword advertising with third-party trademarks, this was always ruled as being a trademark infringement. So as I said, for example, if Samsung would advertise on Google and using AdWords for iPhone to mislead customers to their own homepage, this would be a trademark infringement. So there have been numerous case law from the Federal Court of Justice, Impulse, Mosspralinen, Fleurop, and Autocomplete Funktion. So I will split into these two cases separately because it's a little bit better to understand. For the first of them, Ortlieb, so they, as I already said, they produce bags and cases, waterproof cases, in the upper price range, quite famous in Germany, as I said, but they do not directly sell through Amazon. However, third parties do and are allowed to do so. And Amazon also has their own product range, and third parties do have their own product range on Amazon, as you all know. And so then Amazon has tweaked its search engine in a way that when Ortlieb is entered, so when I go to Amazon, I search for Ortlieb, then not only Ortlieb products are offered or displayed in the hit list, but also third parties and also Amazon own products. And then Ortlieb, they went with the POI and they went for trademark infringement. And both instances have confirmed trademark infringement. Over you can see, so the first three hits are Ortlieb from the trademark owner itself, but then comes already an Amazon own product, and then comes, I don't know what, a third party or something. So this is basically what we're used to on Amazon. That if you enter a special trademark or brand, that in the later range, maybe the first 5 hits are from the same brand, but later on Amazon shows their own products and mixes them in, blends them in to show them to you as a search result. So as I said before, there has been some case law, but not in this way. So the Federal Court of Justice decided in 2 head notes. First of all, the owner of a search engine is using a trademark as a keyword if he bases the list of his hits on automated analysis of user behavior, which is okay in the first way. And the owner of the product cannot influence this list. So this is the problem. Me as a trademark owner, I have no influence editing or being on this list or being not on this list. This is the more important one. If an average user, so this is the informierte Benutzer in Germany, the fictive person skilled in the art for trademarks, if he or she cannot or only hardly understand if the list of hits of an internal search engine are products from the trademark owner or a third party, the indication of origin, so the Herkunftshinweis, Herkunftsfunktion of the trademark might be affected. But the twist is in the word might. The Federal Court of Justice has remanded this back to the second instance, so to the OLG, the Higher Regional Court, to decide on this effect, if in fact an average user can or cannot understand the origin of a trademark in a hit list. So knowing this and also knowing what the head judge said in the decision, he said he is quite sure that the Higher Regional Court will decide that a skilled person in the art or an average user can understand and can differentiate. So basically this is not a dismiss, but the outcome should or will be from the second instance that this trademark claim would or will be dismissed. Because as we all are used to this, and you all have been browsing on any shopping platforms, of course, if the first 5 hits say Ortlieb and the second 6th hit does not, we understand that this is not from the same trademark owner. It's just common or basic knowledge. So for GoFit, it was a bit different. They produced this special fitness mats, health mat, they call it, Gesundheitsmatte, and they do not sell it on Amazon, neither directly nor through third parties. So there are no GoFit products at all on Amazon. And Amazon then went on again and has tweaked the search engine so that when you enter GoFit or even GOFI, it autofills in to GoFit mat or GoFit matte, GoFit health mat, or even GoFit foot reflex zone mat. So basically autofilling in for the user to allege what he's searching for, but not having this product on stock or list or anything. So being not able to sell this product to a customer. So in the first instance, Regional Court of Cologne, LG Cologne, has confirmed the trademark infringement. Higher Regional Court has dismissed already, and the same goes for, there you can see it already, if you enter GoFit, and then Amazon autofills in for GoFit, Gesundheitsmatte, you see the fourth one, GoFit Matte, and all that stuff. So the first head note was about if this is a trademark at all, because it was not a registered trademark, but maybe a Firmenkennzeichen, so this is not relevant for this case. In the second head note, the Federal Court of Justice ruled that the owner of a search engine, so Amazon again, that uses autofill and displays these autofilled hits as an annex to the search term is using a trademark. So it's a use, but it's allowed use. So this is what the third head note says. The use of a trademark as a keyword for the display of autofill-ins is not an infringement if only alternative products are displayed in the list of hits and the indication of origin of the trademark is not affected. So it basically then decided that the trademark is not affected, the origin of the trademark. And the Federal Court of Justice has dismissed the case. So yeah, basically lessons learned. Federal Court of Justice has continued and refined its previous ruling, in particular with regard to search engines, in particular not Google, not public, but platform internal search engines, and autofill in within these platform search engines. And while both cases might be, or the one is and the second one will be dismissed quite surely, there has to be taken some care when using AdWords or Google AdWords or autofill in, however you use that. It has to be taken because it still might be a trademark infringement in a different case setup. I have the decisions for you, for a German speaker. Any questions from you?
Yes, I have a question.
Yes, please.
So when you say care must be taken, to me this sounds like a bit contradictory to the decisions, because the decisions, so far as I know, is that the search terms are not falling under trademark protection. So what care must be taken?
Care must be taken to tell your client that you might be right in the last instance before the Federal Court of Justice, but you won't be in the first or second instance. So if you are going to walk the line, the small line, the thin line between trademark infringement and no trademark infringement, then please be prepared to take the money to go to the last instance. Because in both cases, at least the first instance was pro-trademark owner. And for the first case, it was even in second instance and has been remitted again to second instance and still not decided that it's not a trademark infringement.
Because the Federal Court of Justice gave them some homework for the evidence, right?
Yes, that's the first case. The second case has been dismissed by the Federal Court of Justice, but in the first case, this has been remitted to the OLG to get some evidence and understand this more correctly. And of course, they said this should or will be decided against the trademark owner, but still, it is an ongoing and not so stable floor to walk on.
Yeah, it's an uphill battle, right? In other words.
Yes.
Okay.
Yes.
So do you have the extra homework for the appeal court? What is it the Federal Court of Justice wanted?
So it has given back the decision to the OLG to find out if an average user can or cannot understand the origin of a trademark in a hit list, in the list of search results. So this is basically with regard to the second head note, which is saying it is a trademark infringement if the average user cannot or can only hardly understand if the list of hits of an internal search engine are products from the trademark owner or a third party. Then
how would one evaluate that? Would they do a survey, or what would be the required means of evidence? Is there anything said about that in the decision?
No, to my understanding, this is not even keine Beweiserhebung, so there has to be no evidence or something, but the OLG has to take a position in this question. Es muss dazu Stellung nehmen, es muss sich dazu beziehen, was es nicht hat. That's the reason.
Okay, so if the trademark owner cannot provide evidence, then the case is lost, of course, because now everybody would know, now we need to show that the average user does not understand the origin of a trademark in the hit list, meaning that, thanks for the hit list, meaning that when he types in Ottlieb and he would see the 5 bags, he would think that all the 5 bags go back to Ottlieb, right? And now the trademark owner must bring up evidence which shows that this is the case.
The average user is not sure or is confused by the search results. I mean, of course, you can play it both ways. So if the brand name, if you see the screen, if the brand name for Ortlieb is in the first place, of course, and for the fourth one, which is an Amazon-owned product, this Tatonka brand, that's the Amazon-owned brand, is also in the first place. But if you have a small screen and you put all the words before that and only use the trademark name in the end, then a user might not differentiate between these, because they would say Radtasche, Black Roller, City Par, something, and then Ortlieb would be cut off maybe. So
but
I think
again,
this is the form of presentation.
By this way of putting the requirements when refusing the case back to the second instance, Federal Court of Justice also said who would be the one who need to bring up evidence that this is not the case.
I'm not sure if there's a direct hint for this, because it's the one that wants the stuff in his favor has to bring the evidence. There is no hint from the Federal Court of Justice saying, okay, now Ortlieb, you have to bring on whatever evidence you can get. It is just remitted or referred back to the OLG to decide on this.
Interesting question, because depending on what the appeal court now says, other trademark owners would or would not easily sue someone for a similar trademark infringement, because this would then determine the outcome of the case. Interesting.
Yeah, but it's in the hand of the search engine owner. As I just said, Amazon is bright enough to put Ortlieb in the very front, and the other brands as well. So it's in their favor. They say, no, you just look at it. Ortlieb stands for the 3 Ortlieb products, stands in the first place, and for the others it doesn't. So it's not in the hand of the trademark owner, but of the alleged infringer, how to present. And I would rather say, if this would be presented differently and not so clearly, then it would maybe have gone out the other way, because Amazon went through, I think, a lot of legal battles that didn't make it to Federal Court of Justice, and that haven't been published to come out at their way they present it as they do it now.
Interesting. Very nice case, and I like the presentation very much.
Thank you very much.